question is of responsibility versus abdication and not really activism versus restraint.
So I just want to follow up on that. You say that the choice between activism versus restraint is a false one. It's more responsibility versus abdication. There's also the balance that needs to be found between judicial, the right to fair reputation of a judge versus the right to transparency of the public to know what the judge holds, right? There is now a new move that your successor has made that all judges have to declare their assets. I know it started under you, and at the last time we met, I think you said 30 out of 35 judges have already declared their assets and put it on the website. Now he's made it mandatory for everyone. Do you feel there is a need in this country to restore full faith in the judiciary when it comes to the question of assets, when it comes to the debate that we're having about judicial reform, etc.? And how do you speak to that need?
It's important to understand that right from, I believe, 2009, there was a resolution of the full court of the Supreme Court that all judges must declare their assets. Now, as you know, all of us as citizens have to declare our assets for the purposes of income tax. And all judges are like individual citizens. Income tax pays. So when you file your returns, you necessarily have to disclose your assets, which are dealt with, in certain cases audited. Now, the resolution which was passed by the Supreme Court of India was that declaration of assets by all judges, including the Chief Justice of India, is mandatory. Whether they should be put on the website should be left to each individual judge. Because there is more to be said on both sides of the picture. Should you have judges' assets declared on a website so that just anybody can scrutinize what kind of assets which you have? Or should this be subject to some level of responsible institutional mechanisms? What is the purpose of declaring your assets? To identify whether a judge has recorded a sudden spurt in the assets during the course of the judicial career. Now, does putting that on the website necessarily pursue the aim of transparency? Or does it only give an opportunity to social media to pick up a judge and target a judge, not knowing where those assets came from? You have judges, for instance, let me share with you. You have judges who have come to the Supreme Court from the district judiciary who have been salaried employees from the first day of their joining the judiciary. On the other hand, you have lawyers who have been extremely successful, lawyers who have been recruited directly from the Supreme Court, bar, to become judges of the Supreme Court. Their asset base would be very different. Then you have people like me, who were lawyers for a while. I practiced for 20 years and then became a judge of the High Court in 2000. So there is a broad diversity within the Indian judiciary itself, in the higher judiciary. So far as the district judiciary is concerned, again, there are very stringent rules which apply across the states, which requires for a disclosure of assets. So yes, I completely understand and I support the decision which has been taken. I support the decision which was taken by my predecessors a decade ago on the declaration of assets. To what extent should you have transparency? That's a very important question, and that's a more vexed question. We shouldn't, in the name of transparency, be doing something which will prevent genuinely competent people from entering into the institution of the judiciary. And that's the one danger which we have to balance out.
You know, while we speak of institutional transparency, we are in a stage of live streaming where we have regional judgments now coming in. What more steps do you feel that, can come in as far as institutional transparency, either at the Supreme Court or the district judiciary is concerned, so that everybody can actually access the law, everybody can know how court proceedings go on? Because already we have steps. You had initiated, live streaming. You had a robust system of live streaming, simplified judgment. What more can be put in as far as, increasing this institutional transparency is concerned?
Let us begin with legislation, the process of forming laws. Now, a very welcome step which was taken by the by Parliament and therefore by the government while it moved the Finance Bill of 2025 was to simplify the Income Tax Act. And just to give, the viewers some figures, there were 47 chapters in the Income Tax Act, which have been brought down to 23. There were 819 sections, which have been brought down to 536. There were 5.12 lakh words in the Income Tax Act, which have been brought down to 2.60 lakh words. There were 1,200 provisos, the provisos in legislation, provided that, and provided further that. So these 1,200 provisos have been removed. There were 900 explanations which have been removed. So the first step, I think, and I'm not being critical, it's just a process of evolution. It's important that we simplify laws. Say a law meant for maintenance of senior citizens. The senior citizen must be able to understand the law. A law meant to protect women against domestic violence. That law must be understood by those women who are going to seek access to justice. The law is not meant for judges and lawyers alone, right? It's meant for citizens. One problem which you perceive in the law, and I'm sure so many of the audience would also agree with me, is that there is a disconnect between the spoken version of our regional languages and the official version of our regional languages. For instance, my mother tongue is Marathi, but I'm very fluent in Hindi and I know several other Indian languages. Now, spoken Marathi at home or spoken Hindi is very different from official Marathi or official Hindi. Now, how does a citizen understand official Marathi or official Hindi, or that for that matter, official Tamil or Malayalam or Telugu or Bangla or Gujarati or Punjabi? So we have to bridge this gap between the way laws are drafted in the official text and the laws as they should be understood in the language which citizens speak. So the first step is, of course, the Saral movement. Make laws more Saral, make them more simplified. The second, insofar as what the judiciary should do. Now, I must share with you one of our initiatives when I was Chief Justice of India. We began a monthly newsletter through the Center for Research and Planning, and every judgment which was delivered by the Supreme Court, the judgment may be 50 pages, it may be 500 pages, we would put into a small paragraph in very simple terms what that judgment decides, so that the common citizen must know what is it that this judgment has done for me. That is something which we have done. Almost all the important judgments from independence, we tried to pick up the most important among them, simplify them, and to put them on the website of the Supreme Court for allowing for citizens to understand what the content of the judgment is. And the third and final thing, which is that the language of judgments has to also be simplified. Legal language is extremely complex. It's all jargon. There's so much of Latin, audi alterum partem, or, nemo judex insua causa. Good heavens. Citizens are not concerned with, Latin of some bygone age. Or you have words like thereunder and whereunder and heretobefore and hereinafter. Stop using these kind of words. I think we need to simplify the way we write, because who do we write for? You write for citizens. And therefore, language has to be a lot more simple. It's extremely difficult to be simple. It's very easy to be complex. That's one thing that we need to do. Final thing, live streaming. Live streaming, I think, has been a very critical part of our outreach to citizens. Live streaming of court proceedings has taken the work of particularly the Supreme Court and the High Courts to the homes of Indian citizens. It's also, democratized access to justice. A citizen across India, citizen sitting in Meghalaya, can appear and watch proceedings before the Supreme Court. When we had the Lok Adalat, we had citizens all over India watching what we were doing in the Lok Adalat. So it sort of allows for citizens to participate in the work of the courts.
I do want to ask you, the Supreme Court recently delivered a judgment, upholding the right to freedom of expression, particularly in the context of comedians and poetry and satire and so on. So you have that on the one hand, and then you have, and earlier on in one of the answers you talked about how judges are at the receiving end of social media criticism, right? And you have been a victim of that as well. One day you're celebrated as a poster boy of liberalism, the other day you're criticized because somebody didn't like a judgment that you wrote. How does one balance the two? The larger debate about freedom of expression and, should it be absolute or not? And two, what do judges do when you're this is the day and age that you live in. You are, whether you like it or not, subject to social media scrutiny. There are things you cannot say, but, your image gets tarnished. So how does one draw the balance?
Speaking for myself, free speech and a marketplace of ideas is critical to Indian democracy. And that's why the framers of our Constitution incorporated Article 19(1)(a) into the Constitution. Freedom of speech and expression is non-negotiable. And that's why we are here today on this platform, because our society, our Constitution allows for this discourse. Now, when you have discourse, that discourse is not going to be as civilized as, say, the discourse in a rational forum. Sometimes the discourse can be very pungent. But my own take is that so be it. Let people decide. If you don't like a movie, don't watch it. You don't like a book, don't read it. Nobody compels you to watch a movie. Nobody compels you to read the book. The danger arises when you have prior censorship.